So today we are talking about consumer rights and corporate power. We are going to, I guarantee, make agreements great again. Let me just say, first of all, thank you to everybody for doing the homework. We'll talk about that a bit later in the lecture. But what we're going to do now is we're going to get straight into it with, I think, one of the most important topics that we get to, practically speaking. The Consumer Rights Act makes more difference to more people's lives on a day-to-day basis than perhaps any other part of contract law that we studied, simply because we are constantly buying things, whether it's food, electrical equipment, using terms and conditions or being bound by terms and conditions when we use things or buy things online. So this, I think, is a really important lecture and certainly an important part of the law that we are going to focus on. Of course, my name's Ewan McGahey, and there's my email address and Twitter if you want to follow along. So let's get right down to it. What I want to do today is start off with a quote, this time from Lady Hale. And this is a case that we're going to look at a bit later in the lecture. But what I want to do now is just read out a statement that she made about unfair contract terms as they apply to consumers. So Lady Hale, of course, was the president of the UK Supreme Court until very recently, and is probably one of the most influential judges of her generation. And usually I agree with her, but here I'm going to put forward a statement which I think is a bit problematic. So in a case called OFT and Abbey National, Lady Hale said, as a very general proposition, consumer law in this country aims to give the consumer an informed choice rather than to protect the consumer from making an unwise choice. She goes on to say, should financial services be treated differently from other goods and services? This was a banking case, as we will see a bit later on. Or is the real problem that we do not have real choice because all the suppliers offer much the same product and do not really compete on some of their terms? That's the situation here, she says, about this case. But it's not clear to me whether the proper solution is to find some way of forcing suppliers to compete with one another in the terms that they offer, or whether the solution is to condemn one particular model of charging for those services. So this was a case about whether people could be charged unplanned overdraft fees on their bank accounts. And what Lady Hale is doing in this passage is she's saying, well, I'm not sure whether unfair terms in consumer contracts should really be regulated to such an extent. And as we'll see, the UK Supreme Court ended up ruling against consumers in OFT and Abbey National very controversially. Or she's saying, well, maybe the solution is really just to ensure that competitive markets work better, even if, as is the case in many situations, we've got a banking market which is characterized by very unequal power, natural monopolies, and all sorts of market failures, which you would do a lot more of in competition law or enterprise law. But the basic point that I want you to focus on now is, here is the proposition that consumer law, as a general proposition, she says, is based on giving consumers information, but not regulating so much the terms of their contracts to prevent people, as she puts it, making an unwise choice. But I actually think this is the wrong framing of the point, or the wrong framing of the problem, because the real problem is that consumers, not that they're unwise, but just that they lack power in the markets to get the sort of deals that would be objectively good. So the question I want to put forward is what Lady Hale's saying here true? Is the aim of consumer law to just inform people, or is it to create substantive rights? Okay, so I'm going to make four main points over the course of this lecture. The first is that consumer rights to fair contracts are necessary for economic and even democratic stability, because I want to argue they counteract consumers' unequal bargaining power, individuals against big businesses particularly, so consumers' unequal bargaining power against massive corporations and banks, as we will see a bit later on. Without rights, we get, without consumer rights, we get crises, from financial crises to whole-scale economic collapses and depressions. That results in political extremism, and as Friedrich von Hayek once put it in a very different context, this leads us to the road to serfdom. So this is a very serious issue, and I don't want to scare anybody, but I want to argue that consumer rights are at the foundation of a successful economy, and ultimately democratic stability depends on it. The second point that I want to make is that rights replace the arbitrary outcomes of rigged markets. But the case law that we've seen in the UK shows the courts are giving an unduly narrow interpretation to the law, and therefore in the outcomes on the cases before them. We see that particularly in Abbey National and OFT that we just mentioned before, we'll get to later, and another big case called Parking Eye and Bevis, also in the UK Supreme Court. My third point is going to be that the European Union court's approach has been preferable. Their case law, by and large, has got it right. Not always, but much better than the UK court's record so far. And the fourth point is that public enforcement of fair terms has been severely lacking in the UK. It's been almost non-existent, meaning that contracts with unfair terms are common and they are systemic. We see unfair terms used in real life all the time, as many of you have sent me already, and as we've seen in the lectures. And what we really need is a new approach. So those are going to be the four main points for today. Okay, so the first thing to do is give you some background about modern consumer rights law and global economic stability. And I'm going to try and show how these things really are linked in a very serious way. We're going to look at Franklin Roosevelt and JFK, the global financial crisis in 2007 and 8, and the knock-on effects into the Eurozone crisis and the ongoing political crisis that we see even up to today. And I'm very conscious that this is going back across many people's childhoods, but I hope that I can give you some narrative which I think is also useful to understanding how the modern consumer case law has developed. Okay, so the first point, or the first place to start, is really with the Wall Street crash of 1929 and the Great Depression. Now, as many of you will already know, the Wall Street crash was the collapse of the stock exchange, the New York Stock Exchange in particular in the United States. And this was really caused, or certainly triggered in the 10 years running up to that, by the non-disclosure of terms in contracts for the sale of company shares. So what was happening is that lots of people were buying into company shares on the stock market, and the companies selling those shares weren't under effective obligations to disclose what was in the stuff that they were selling. You know, what was the company doing in which stock was being sold. And so lots of people got ripped off buying into companies which were not really doing very much, which, you know, were selling patches of swamp in Florida or dodgy real estate. And that meant that an asset price bubble grew and grew and grew because people were overpaying for the things that they were buying. This was also due to the absence of a public pension system in the United States at the time, or what the Americans now call Social Security, because the US Supreme Court had continually struck down all social and economic legislation, all social and economic rights under this idea of freedom of contract embedded in the Constitution. And one of those things included the courts saying that public pensions were unconstitutional or would be incompatible with law. An example of that, and there are many, is called Buck-Steger and the state of Arizona. So the combination of absence of public pensions and lack of disclosure meant, well, first, loads of people put their money or their savings into the stock market and didn't really know what they were buying because there was no portfolio duties, disclosure duties. And so you had this big asset price inflation. And when people realized that, you know, companies weren't really doing that well, you had a crash. And that was the Wall Street crash of 1929. This rolled on into the Great Depression because of several big mistakes by the Republican president and controlled Congress at the time, including shutting down international trade, but really having no plan to stop the spiral into, well, companies losing money, therefore businesses losing investment, therefore businesses firing workers, no job security. So, workers lose their jobs, they have no income. That means that they buy less as consumers. That means that businesses have less income and they fire more workers, and so on and so on. So, you get this downward spiral into the Great Depression. And this was really terrible. So, you had around 21% unemployment in the United States at the time. This is the foundations for a really revolutionary situation. You can see that in the charts that I put in my slides. You've got US unemployment from 1892 till 2020, and you see the big spike at the beginning of the 20th century. That's the Great Depression. And I think it's important to see that, in a less stable political system, things could have turned out very, very differently. A less stable political system was, for example, Germany, where the Great Depression brought a psychopath with a silly moustache called Adolf Hitler to power, and you see in exactly the same circumstances of mass unemployment and economic crisis. But the reaction to this in the United States was the election of Franklin Delano Roosevelt. The Republican government was removed, Roosevelt came to power, and as we've mentioned before, he set about building what he called the Second Bill of Rights for fair pay, food, clothing, recreation. He said that everybody, if you were a farmer, should have a right to a decent living. There should be freedom from unfair competition if you were a small business. Or if you're a medium-sized business, against big corporations' power. He said that everyone should have the right to a decent home, good health, protection from the economic fears of old age, sickness, accidents, and think about, again, medical care and about COVID even today. And people should not have to fear economically from unemployment, and people should also have, the right to a good education as well. So that was the New Deal, as we've seen before, all summed up in this idea of a second bill of not just civil and political rights, but economic and social rights that should be seen as just as an important part of the American Constitution, though done through legislation. Now, these ideas went straight into the Universal Declaration of Human Rights of 1948, the Magna Carta for All Humanity, according to Eleanor Roosevelt, who drafted or took part in drafting it. And this is a core part of international law today. But there wasn't necessarily anything in the Second Bill of Rights or in the Universal Declaration specifically about consumers. And so this is where JFK, President John F. Kennedy, comes in our story in 1962, when he proposes what people have later called a Consumer Bill of Rights. And he said that there should be, not just, the rights that we've enumerated, like, to decent food and housing, but there should be a general idea, a general conception that anybody who's a consumer has certain basic rights enshrined in the law. So in this speech in March 1962, JFK says that additional legislative and administrative action is required and that consumers should have 4 basic rights, which I think is still a good framework for thinking about what we've got in the law today. First, he said that there should be a right to safety, to be protected against the marketing of goods which are hazardous to health or life. So if you buy a toaster, it shouldn't blow up. If you buy a mobile phone, it shouldn't explode, because something's wrong with the battery. So the right to safety. The second thing is he says that there should be the right to be informed, to be protected against fraudulent, deceitful, or gross misleading information or advertising. And so, think about the Misrepresentation Act from last term. These are sort of things that consumer protection, more broadly, and in fact, even more broadly than what we're going to do today, extends to. The third thing is the right to choose. And in those industries, says JFK, in which competition is not workable, so outside of the ordinary patterns of private enterprise where markets seem to work, there are some markets which fail. Particularly one example might be health or indeed banking, education. So in those industries in which competition is not workable, there should be an assurance of satisfactory quality and service at fair prices. And perhaps even we might add free services funded through tax. Fourth, he said there should be a right to be heard, fair and expeditious treatment in administrative tribunals. So, you should have a right to an effective remedy as a consumer, not just the right to go to court, but make sure that the courts effectively uphold your rights. And also, he said consumers should have a right to take part in the formulation of government policy. So all these rights for consumers were what JFK talked about in 1962, and it was an inspiration in the UK for our own legislation about a decade later. So we saw the growing number of bills. First of all, the Consumer Credit Act in 1974. Then we had the Unfair Contract Terms Act in 1977 being put into our law, originally up to apply to consumers. Now, of course, we've got the Consumer Rights Act 2015, which we're going to get to. And it was a big inspiration also for what happened in all European countries and led to, in the European Union, the Unfair Terms in Consumer Contracts Directive of 1993. But our story doesn't end here for America, because although, following JFK's call, there were many different regulators set up to protect consumer rights, there was new legislation passed, much of this depended upon the executive branch. And from 2000, there was a president called George W. Bush elected who, wasn't really interested in enforcing any consumer rights, and on the contrary, was really in the pocket of big business, since, of course, the Republican Party is bankrolled mainly by major corporations whose interests are very different to what we see in consumer rights law. So from 2000, when George W. Bush came into the White House, there was an effective halt in enforcement of consumer protection legislation, particularly in housing and loan markets. And this is where the global financial crisis of 2007 and 2008 really began. Now, a lot of people sometimes find finance a bit bewildering, but it's really not. And we can understand what are, perhaps some, complicated ideas, or, certainly with complicated jargon, in a few simple steps. So the global financial crisis of 2007 really began with the American mortgage market. So there you see at the bottom of the slide, I don't know if you can see my cursor, there you've got somebody in a home. Let's imagine that they're living, I don't know, in Louisiana or Kentucky, and they just bought their house with a mortgage, but you've got perhaps a couple, and they're both working, really hard. Let's say they're working in Walmart, they take second jobs in Burger King, and they're working and struggling at a minimum wage and just getting by and paying the bills. Now, the big problem was that when people got mortgages in the early 2000s, and even up till the financial crisis, they could often get 0% interest rates for a big loan on their house. But then, buried in the contract terms, buried in the small print, there would be a clause saying that the bank could vary the interest rate according to its discretion. So it could potentially put up the rate to something very high and something unaffordable, 10%, 15% interest per annum, who knows what. So you have a teaser rate of 0% and then a discretion in the contract terms to vary the interest rate to something potentially very high. Now, this matters because mortgage debt, the payments that people make on their mortgages, their interest repayments, are being sold by the mortgage lenders and those retail banks to other banks. So they set up something called a special purpose vehicle, which is just a company, to receive all the income payments that are being made from the home buyers into, to pay off their mortgage. The special purpose vehicle then holds that money, but issues different kinds of bonds, which again are rights to receive the income being paid up. So these bonds are called collateralized debt obligations. Sounds really tricky, but it's actually quite simple. So the collateral is the home at the end of the chain. The debt is the debt on your mortgage to make interest payments, and it's just an obligation, but you call it a collateralized debt obligation. And there can be different kinds of collateralized debt obligations, or CDOs, issuing different ranks. So you could have A CDOs, B CDOs, or C CDOs, and the top ones get paid first, and the bottom ones get paid last if there is any problem with payment. So these are financial products. These are bonds being bought and sold by banks because ultimately it's the right to receive an income stream. Yeah. And you have these actors called credit ratings agencies, Standard & Poor's, Fitch, Moody's, and they're in on the business, and they rate the CDOs, or the different products that are being sold, according to what they say is the security of the product that is being bought. But the really big players in all of this is the next step of the chain. It's the investment banks. So things like Goldman Sachs or JP Morgan or Citibank, or in the UK, Barclays or HSBC or Royal Bank of Scotland. And what they are doing is they're taking these CDOs and they're then making other contracts on top of them. We call these derivatives. So a derivative contract is a contract which derives from another one. So you might have an option to buy a CDO in future, right? Or you might have an obligation to buy a CDO in future at a particular price, or on a particular date. So whenever you have a contract made from a contract, we call that a derivative. And many of you will probably have heard derivatives. These things get traded all around the global economy and amongst the global banks. Now, let's think about this for just a second. If you are a bank, or let's say that you're a pension fund or another investor buying financial products from a bank, and you hear that you can buy a derivative from a CDO, from an SPV or a special purpose vehicle, you might think, that sounds quite sophisticated. But in reality, all you're getting is the right to an income stream from somebody struggling to pay off their mortgage at the end of the chain. Now, what was happening in the mid-2000s is that more and more people were struggling. One of the biggest causes of bankruptcy in the United States is just people getting sick, and because there's not universal healthcare, people would get a big medical bill and they'd be forced into bankruptcy. They couldn't make their home mortgage repayments. And these problems were building up over the 2000s, and they came to a head in 2006 and 7, when suddenly, all of these special purpose vehicles and collateralized debt obligations, and then the derivatives, by now being traded in their billions and trillions right around the global financial system, suddenly become worthless, because if the person at the end of the chain isn't paying off their mortgage repayment because the mortgage deal has been put up to 15% interest per annum, 20%, and they're really struggling to get by, that means that all of the derivatives are worth nothing, and that means that a big chunk of the bank's financial balance sheet is also worth nothing. And that's when the banks start to collapse. So the first one was Bear Stearns, then there was Lehman Brothers, then there was Northern Rock in the United Kingdom, Royal Bank of Scotland, and so massive holes in banks' balance sheets, and that's why you've got a financial crisis. This leads to a number of massive problems, ultimately the government having to bail out the banks, with the potential for the total collapse of the economy in a way that could have been exactly like the Wall Street crash or the Great Depression. So to sum up, what caused the financial crisis was, number one, no real control of the unfair terms in US mortgage contracts. In other words, an absence of consumer rights, which we did, by the way, have in the UK and the European Union as well. But the problem is that because all the global banking system is connected, all the global banks are trading with one another, from American banks to UK banks to banks in Germany and France, that means that the derivatives from US mortgage contracts don't stay just in the United States. So the first problem is absence of consumer rights in mortgage contracts, meaning people get ripped off, they lose their homes, they go bankrupt, and this affects the whole global financial system. The second thing is that you have these conflicted ratings agencies, because believe it or not, they were being paid to rate products and saying, oh, this one's AAA, by the people who were selling the products to them. So that obviously is a big conflict of interest if you're paid by the person whose products you are rating. And the third problem was no adequate disclosure duties, basically rules of good faith enforced in derivative contract markets. So investment banks like Goldman Sachs, JP Morgan, Barclays, Citibank, RBS, Lloyds were overpricing these junk bonds, inflating the asset price bubble, which eventually comes to a bust. And if you want to read more about the background of all of this, then I highly recommend Elizabeth Warren's article, Product Safety Regulation as a Model for Financial Services Regulation. Elizabeth Warren was a stellar insolvency and bankruptcy professor in Harvard Law School, now a US Senator, and some of you, of course, will know her presidential run. And John Coffey, who is at Columbia University, on what went wrong in the global financial crisis. Now, the immediate consequences of all of this was, as I mentioned, that the UK nationalised, or was forced to nationalise, its insolvent banks. So the banks are saying, well, we might not be able to pay our creditors, and then the next bank can't pay its creditors, and suddenly all the banks are insolvent, and that means businesses don't get loans, people get sacked. So you don't want that. So Britain nationalised its banks with a substantial amount of government money. And passed new legislation in Emergency Banking Act 2009 and all of that. The United States did something different. Initially, still with the George W. Bush government, it decided not to nationalize its banks, but to go much softer and just simply give them money. So great. We're going to give banks a whole bunch of money for the mess that they have themselves created. But that's what they did, and this was called the Troubled Asset Relief Program, where essentially the US government guarantees the bad debts that banks have created themselves for themselves. Now, on the Troubled Asset Relief Program Oversight Committee was the new US Senator Elizabeth Warren, appointed by Barack Obama, and she was meant to look at how the money was being spent. And the upshot of all this is, despite the massive cost to the public as a result of private recklessness and greed, despite the massive cost to the public, a disaster like in 1929 was averted. At least an immediate disaster was averted. But the broader consequences continued, because with all of the financial system thrown up in the air and all of these problems about credit and about the contraction of the amount of capital that banks had to do business, you had also a contraction of international investment right around the world. So if you sort of think of the global economy as having different centers of power and different centers of capital, and you see a contraction of how much money is being circulated in the United States, or how much money is being circulated in the European Union and the United Kingdom, then you can imagine that a contraction in the centers is also going to mean a contraction in countries which aren't big financial centers, but also depend on their economies, around the peripheries of the crisis. So that was particularly true in countries within the EU like Greece, like Portugal, Ireland, then just outside Iceland. They all had terrible collapses. And then going a bit further, we saw in 2011 the beginning of the Arab Spring, in the context of massive unemployment, because also there was an economic contraction from Tunisia to Egypt to Libya to Syria, and then also in Eastern Europe, in Ukraine and in Russia. And this sets off geopolitical consequences. Wars start breaking out, revolutions start breaking out in the context of an economic collapse. Now, I want to focus just a little bit on the European Union, because in particular Greece was very badly hit by falling tax receipts, and it was struggling to pay its national debts, owed, by the way, mainly to British, German, and French banks who were bondholders in Greek debt. So just like a company, a country can borrow money from the international financial markets. But if you've got a contraction of financial investment worldwide, then that means that the amount of money that is available to lend countries money as well is going to be limited. And what happened is a lot of investment banks, the same ones that had caused the global banking and financial crisis, started betting on countries like Greece not being able to repay their sovereign debt. Some banks traded what we call credit default swaps that would pay out if Greece defaulted. And I don't know if any of you have seen, but there was a fascinating story just last week or the week before about Reddit users and hedge funds. So, it's basically kind of the same thing going on here, or the same kind of credit default swap gambling that the banks were doing. But here we're talking about a country, Greece not being able to repay its sovereign debt. Okay, so this leads into the Eurozone crisis. So from the financial crisis into the Eurozone crisis, because ratings agencies, again, the same ones as before, whose shareholders are the banks, start rating Greek sovereign debt as junk. That puts up the Greek interest rate repayments, right? So if you've got to repay like 100 million euros at 2% interest per annum, but suddenly, and that's your initial repayment rate. But then the interest rate is rising to 10% or 15% because you are not seen as able to repay. Well, that becomes a self-fulfilling prophecy. In itself, it's making you less likely to be able to repay. So Greece, the whole country needs to be given a loan by the European Union. And this is what happens in what's called the Memorandum of Understanding. Greece gets money from what's known as the Troika, the IMF, the European Commission, and the European Central Bank. But in return, they say, well, we're not just going to give you this money for free, even though this crisis is created by the banking system. We're going to say that you have conditions like cutting the minimum wage, like cutting pensions, like cutting public services and privatizing them. This is what is euphemistically known as structural adjustment. Now, this sets off another crisis in itself, and you can see it from the charts on unemployment, like one I've got here. As soon as the Memorandum of Understanding is made, requiring Greece to make massive cuts in what we refer to as austerity, but austerity on steroids, there are disastrous humanitarian consequences. Unemployment goes through the roof to 25%. Youth unemployment is up to 50%. There are electricity blackouts. There's more homelessness. There's riots. You have the growth of fascism again. A party called Golden Dawn exploiting people's insecurity and their fear. And this leads to an increased rate of suicide, mass exodus of Greek people because of the financial collapse. And the same consequences are being echoed right around the Eurozone and indeed right around the world. So part of the fallout and the ongoing instability of the financial crisis within Europe, outside Europe, in America, is the rise of far-right politics, many of which are, of course, astroturfed by Putin's Kremlin. So they have frightening success. Parties, like Le Pen's party in France, the Alternative für Deutschland in Germany, Lega Nord in Italy, UKIP and the Brexit Party in Britain, and of course there's the orange man with the little hands, Donald Trump, in the United States. So all of them are arguing that democratic politics have failed. They're also, interestingly, all climate change deniers. They're saying that it just doesn't work. And so these are the political consequences that start with the global financial crisis and ultimately start with the lack of consumer rights protection. We see the continuation of authoritarianism today. Donald Trump is out of the White House, which is a very good thing. But in China, you have an increasing authoritarian position being taken by Xi Jinping. In India, you have a frightening shift in its politics under Modi. So the crackdowns in Hong Kong on democracy and human rights, the withdrawal of statehood in India. And so all of these are the very, very real political consequences that flow from economic crisis and ultimately come back to what we have in the law. And of course, in Britain, one of the consequences of the financial crisis and then austerity, which resulted or was carried out by the government afterwards, was that people had the longest wage cuts since the Industrial Revolution. And this was all in the lead up to the Brexit poll of 2016. Now, I want to say that consumer rights are not the only things that, of course, cause all of these incredible political dynamics, but they are important contributing factors. They're not the only things, but they are very important for understanding why we have economic crises and political rupture today. So that, I think, is the background. And so now, with all of that in mind, we're going to come to the core of unfair terms. And I want you to think, as we're going through the case law, and particularly the timeline that we see in the cases, I want you to keep in mind what was happening in the world and what was happening at the time when we see these cases being decided by the courts. Okay, so now we're going to get into some law, and the tone is going to be a tiny bit lighter. This section is going to be about the idea of core terms in consumer rights contracts, good faith and balance in consumer rights. So, the starting point is that, as I said before, we have the Unfair Contract Terms Act and other legislation, and then we have a European Union directive. And this is called the Unfair Terms in Consumer Contracts Directive of 1993. This is the basis for what we now see in the Consumer Rights Act 2015 in the UK. So the purpose of it matters, and the recitals at the beginning of the directive are instructive, not binding, but are instructive about how we go about its interpretation. So Recital 9 says that acquirers of goods and services should be protected against the abuse of power by the seller or supplier, in particular against one-sided standard contracts and the unfair exclusion of essential rights in contracts. So you see, Recital 9 is talking directly about the abuse of power. It's not just saying, like Lady Hale put it in OFT and Abbey, that this is just about information. This is about abuse of power and also essential rights. Recital 16 then says, in making an assessment of good faith, which we'll talk about a bit later, but that's a key norm for deciding the fairness of a consumer contract, particular regard should be had to the strength of the bargaining positions of the parties. So, this is everything that I've been talking about for the last few lectures. This is a piece of legislation that is focused on bargaining power. Now, it's important because of the Brexit poll and the UK's departure from membership of the European Union to say one or two things about the exact relationship between EU law and UK law, because EU law very much does matter still. It hasn't changed in many ways, but let's just say a few points about what the real relationship is between the two. The first thing is that EU law aims to harmonise minimum economic and social rights in the internal market. Of course, it does a lot more than that, but in the famous case of Dufresne and Sabina about equal pay between men and women, the Court of Justice famously said that the European community is not just an economic union, but it's also about ensuring that people have social and economic rights. It's not just about markets, it's also about citizenship and rights. The second point is that member states, if they fail to abide by EU law, can be sued for failure to properly implement a directive, if there is one, or a regulation. And this can even extend to courts getting it wrong. Now, that doesn't apply to the UK anymore, but of course, many of us are also EU citizens, or you're from other member states in the European Union, or you're very likely at some point of your life to go and work there. So I think that all of this is still very important for that reason, if nothing else alone. The third point is that courts have to refer to the Court of Justice for a preliminary reference unless, so that's a national court, if there's a claim being brought, they have to refer the national court to the Court of Justice to decide what the right meaning of EU law is, unless the meaning is so obvious as to leave no scope for any reasonable doubt. So if we're looking at a directive, we're not sure what it means, and we're a national court, we should refer in the case of doubt. So what does Brexit mean? Well, first of all, it means that preliminary references are ended for the United Kingdom. Secondly, it means that the treaties have been replaced by what is now the European Union UK trade agreement, and the wonderful consequences of all of that are unfolding before our eyes. The third thing is that, well, directives are still implemented in UK law by Acts of Parliament or secondary legislation like regulations. So that doesn't really change at all. So, the Consumer Rights Act is based on the European Union directive, but we still interpret the Act according to the intention of Parliament. And the intention of Parliament will have been to follow what was happening in EU law, at least to those minimum standards. So in that respect, things don't change very much at all. And when we're looking at an EU regulation, so in competition law, for instance, you have the merger regulation. There's the difference between directives which are further implemented and regulations at EU level which are not. Well, those come into UK law by virtue of the European Union Withdrawal Act 2018, Section 3. So again, nothing really changes. But of course, the big thing that has changed is that everybody who is a UK citizen lost their voting rights within the European Union Parliament. And so that means that we don't have a say anymore in the UK about what the European Union's legislation does. But it would be completely wrong to think that this does not affect us because now the UK is a supposedly sovereign country. Because the international trade system is so bound up together that what one country or one economic bloc does definitely affects another country. And the terms of trade are set in international treaties, which are just like contracts, and they depend on the bargaining power of the countries. So the UK lost a lot of voice and influence through leaving the European Union, and it was, of course, the biggest destruction of voting rights in modern history. But otherwise, everything is pretty much the same. And for our purposes, EU case law is still very important in determining what UK law means, because Parliament's intention was to follow EU law in the Consumer Rights Act, as in other things. Okay, so now let's get into what the Consumer Rights Act says. We start with Section 2. And there's two main differences between this and this piece of legislation and what we did last week in UCTA. The first is that the Consumer Rights Act 2015 deals with unfair terms in general, whereas UCTA, remember, was just about exemption clauses, exclusion or limitation clauses, with the proviso that the Consumer Rights Act doesn't look at the price payable or the main subject matter of the contract. We'll get to that in a few slides. The second thing is that the Consumer Rights Act, unsurprisingly, applies only to consumers, and a consumer, importantly, is defined as an individual acting for purposes that are wholly or mainly outside that individual's trade, business, craft, or profession. Okay, so a consumer is an individual acting outside trade. Now, the contract that you've got is irrelevant to determining who is a consumer. So, for instance, Uber, that great app that many of you will have on your phone, often denies that its passengers have any consumer relationship with Uber as a corporation. And of course, Uber denies that its drivers are employees. It denies that it is a transport company, anything to get out of regulation. But that is something for another time and another place. But it doesn't matter for our purposes whether a contract says that you are a consumer or not. It can deny that you are. It doesn't make a difference. What matters is the application of the test in Section 2. By the way, if you want to look up a case on consumer rights and value-added tax concerning Uber, there's a link in the slides just there. So who can be a consumer? Well, under the Consumer Credit Act of 1974, Section 189 included a small partnership, but not a company. So an individual probably means, under the Consumer Rights Act, somebody who is a natural person right? A natural flesh and blood person like me or you, but not a corporation, not a legal person. That's probably not an individual. So we did have Unfair Contract Terms Act cases holding that companies could count as consumers through the interpretation of Parliament's intent. One of those was called R&B and Customs Brokers, and there's Belderol, but these are probably being superseded by the new rules that we've got in Section 2 of ACTA. That, by the way, also means that maybe there's reduced protection unless you get protection under the Unfair Contract Terms Act itself. Now, then we've got a lot of things in the Consumer Rights Act which are just replications of what was in the Unfair Contract Terms Act, but often at greater length. The Sale of Goods Act in 1979, which we saw before, is basically copied into consumer rights legislation. And we don't need to go into this too much because we've already said it, but just very quickly, Section 9 says that consumer goods have to be of satisfactory quality. So that's like Section 14.2 of the Sale of Goods Act. Section 10 says that goods have to be fit for purpose. Section 11 says that they have to be as described. Section 13 says they've got to match the sample. So if you see a sample of oats, then they should be the same ones as that you buy that were in the sample, so that your horse doesn't get a stomach ache. Section 14 says that it has to match a model, and sections 19 to 24 say that consumers have a right to replace or reject goods that are defective. And remember, this is quite important from an environmental point of view. If we have goods that break down very easily, then that means a lot of stuff is being built that perhaps doesn't need to. Material throughput and ultimately energy use is going to be more than it otherwise needs to be. So all of these consumer rights are the same as what we've seen before. And Section 31 says what we had before, which is that a term of a contract to supply goods is not binding on a consumer to the extent that it would exclude or restrict the trader's liability to rights like these. So basically, you can't get out of them. It doesn't matter if you've got a contract term that says we exclude the right or we exclude our duty for your goods to be of satisfactory quality. It just doesn't matter. Under Section 9, they must be, and under Section 31, you can't exclude or restrict that liability. But now, what about the general control of unfair terms? And this is where we get to the core of the legislation and where all the case law comes in. So Section 62 of the Consumer Rights Act 2015 has the key fairness test. So all terms basically for consumers have to be fair in the following way. And the term is unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer. Okay, so terms don't have to be fair for the big business. And, why would they need to be? Because usually consumers are trading on terms. In fact, invariably they're trading on terms that the big business has written for you. Terms have to be fair, however, for the consumer. They can't be to the detriment of the consumer. And that's got two parts: good faith and no significant imbalance. So it's got to be in good faith and it's got to be balanced. Now, it's a bit unclear from the drafting of the legislation whether or not these are cumulative requirements in the law or they're part of the same thing. We don't really know yet from the Court of Justice. So it could be that there should be no lack of good faith plus no significant imbalance, which would make claims harder for the consumer. Or we could say that good faith is an overarching concept and balance is part of the idea of good faith, by distorting the way that the contract allocates rights and duties. My view is that they are part of the same thing, and that's particularly important because we shouldn't try to make consumer contract claims harder. But that is a debate that hasn't yet been finalised by the courts in the dicta of a judgment. Okay, but then there's an exemption. So it's not the case that the fairness regulation in the Consumer Rights Act applies to every single type of term. So Section 64 says that a term of a consumer contract may not be assessed for fairness under Section 62 to the extent that it specifies the main subject matter of a contract, or that the assessment of the appropriateness of the price payable under the contract by comparison with the goods, digital content, or services supplied under it. So we don't assess a contract term for fairness if that term is about the main subject matter of a contract. So this is a pen that I'm selling you. So one of the main subject matter of the contract would be it's a pen, or the price payable. So if I say I'm going to sell you the pen for £1, one of the terms that we can't assess for fairness is the pen, because that's the main subject matter, or the pounds that you're paying me. So that's an easy case. But I suppose the reason for this exclusion from the scope of the legislation is, well, it could be a number of things. One is that we might not want a general system of price regulation if broadly the markets are working fairly otherwise. But another thing is that unfair terms are usually not the ones that consumers appreciate immediately. They're the ones that are a bit hidden in the small print, so not the main things that would strike a consumer up front. Subsection 2 of Section 64 says that these exemptions only go to the extent that the term is transparent and prominent. Again, can't be a hidden term, it has to be transparent and prominent, and we'll come back to that when we look at OFT and ABI. And in Kasler and OTB Yeltsilog Bank, the Court of Justice makes the point that because these are exceptions to the general rule of the fairness of terms, or the requirement for the fairness of terms, we should construe these exceptions restrictively. Okay, so we regulate the fairness of terms except for the price payable and the main subject matter of the contract. And the Court of Justice has said that because those things are exceptions from the general rules of fairness, we should interpret their scope narrowly. Lord Steyne said the same in First National Bank. But unfortunately, the UK courts haven't quite always seen it the same way. So the consequence of finding an unfair term is that they will not be binding on the consumer. So they could still be binding on a business, but the consumer can elect to say that the term is no longer binding. And Section 67 says that where a term of a consumer contract is not binding on the consumer, the rest of the contract continues so far as practicable to have effect in every other respect. So what we're doing is we're just taking out the unfair term from a contract. We're saying that that's not binding, but everything else continues in the same way. Schedule 2 of the Act and also the annex of the directive helpfully sets out some examples of unfair terms. Often textbooks describe this as a list of, not a blacklist of terms, ones that are definitely unfair, but as a grey list of terms, ones that may be unfair or probably are unfair. My view is that it's very, very likely that if you get one of these terms, they are definitely going to be unfair, unless there are very, very good reasons. And that it can be seen simply by looking at what the content is of Schedule 2. We don't, by the way, have a definitive statement on the court about the effect of these terms, but I think it's very likely that they'll be unfair, because you can see, the first one that is listed is that it will be an unfair term, or it may be an unfair term if you exclude liability for death or personal injury. So that was definitely unfair under the Unfair Contract Terms Act, and there's no reason that would be any different at all under the Consumer Rights Act. Another example in paragraph 7 would be a term that authorises the contract to be resolved by one party on a discretionary basis when a consumer cannot. So, the big business can say, I'm not bound by this contract anymore, but you are, then that's probably going to be unfair. Paragraph 8, allowing termination by the business without reasonable notice. Remember back to last week, there was BT and Timeload doing something very similar to that. Paragraph 10, binding consumers to terms that he or she cannot know. So that would be another example of an unfair term. And, here's an important one. Paragraph 11, allowing unilateral alteration of contract terms without a valid reason. So if you have a contract term that says one party, like the big corporation, maybe even a lecturer, varying contract terms unilaterally, then that is very likely to be utterly unfair under the Consumer Rights Act. And paragraph 20, very important, hindering the right to sue or binding somebody to arbitration, for example, which, to reduce the legal remedies that they have. That has been held to be definitely unfair in a case called Telecommunications and Noguera. And also there's the AT&T case in the United States, which went the other way in the US Supreme Court. And I'll come back to that in a few slides. Now, I just want to go into one case, and then I'd like to have a break. But before we have a break, I'd like to tell you the first leading case that we had in the House of Lords on unfair contract terms for consumers. This was called Director General of Fair Trading and First National Bank PLC. Now, what happened here, again, it's about finance, but it's really simple underneath it. The Director General of Fair Trading claimed that First National Bank's term was unfair. And so what did this term do? It raised interest rates if a borrower from the bank defaulted on repayments, right? So imagine you've got a loan from a bank. If you fail to make repayments, then there's a contract term which raises the interest rate in a certain situation. So this was the situation. If a borrower defaults on a loan, they could get a court judgment for a repayment plan. So we know that you're having trouble repaying your loan. You go to court and the court sets a repayment plan for you to make repayments of the money, perhaps on a more favorable basis over time. And so this was done under the Consumer Credit Act of 1974. And the default rule was that a statutory interest rate would apply under the County Court Interest on Judgment Debts Order of 1991. So this has a certain interest rate set by statute. And First National Bank said, well, no, that default statutory rule is too low. We want a much higher rate after somebody's been told to have a repayment plan under a court judgment. It wanted to have a market interest rate of loan repayments. So the question was, first of all, is this a core term of a contract so that you can't assess it for fairness? And then second of all, once you've got over that hurdle, is this term fair or not? Putting the interest rate up under the consumer credit loan. So the House of Lords held that the term was not within what is now Section 44 of the Consumer Rights Act because it didn't concern the primary price of the bank's services. So that meant it could be assessed for fairness under what's now Section 62 of the Consumer Rights Act. However, despite being capable of being assessed for fairness, remember they're saying despite this being about interest rates, it's not about the price payable. But despite that, the House of Lords ultimately holds that the contract term is fair. It was legitimate, it said, to substitute ordinary interest rates. So this was part of the reasoning from Lord Bingham. He says there's an important distinction between the terms which express the substance of a bargain and those which are incidental and likely to surround the main substance of the bargain. If the object of the regulations and the directive is to protect consumers against the inclusion of unfair and prejudicial terms in standard form contracts into which they enter, and he's absolutely right about that, that object would plainly be frustrated if what is now Section 64 were broadly interpreted to cover any terms other than those falling squarely within it. Okay, so we should be assessing terms for fairness unless there are terms that fall squarely within the price payable under the contract. But even if a borrower's obligation were ordinarily understood to extend beyond judgment, even in the absence of an independent contract, it would not alter my view of the term as an ancillary provision. Okay, so here he's talking about Section 64, and he's saying we can assess it for fairness. But, he says, the substitute interest rate was not unfair simply because, according to Lord Bingham, it was about protecting the bank's own legitimate interests and getting a market rate of interest back, and that if it didn't get that, it would be to the detriment, he says, of the lender. And this is problematic for a number of reasons, but otherwise it's a very well-reasoned judgment. So the first point is that the House of Lords is recognising that exceptions to the fairness test under Section 64 should be construed narrowly in light of the Director's purpose. But second of all, we must ask, well, why did the court not defer to the Director General of Fair Trading, so it's the regulator that's policing these unfair terms, on what its view of fairness was? So why did the House of Lords judge that it was in a better place to determine whether this term was fair against the specialist knowledge of the government regulator? And I say that because the regulator is looking at these sorts of terms all the time. It's looking at unfair contract terms potentially every single day. And so isn't it in a better place to determine what seems to be a problem in the markets rather than the court? So the third thing is that Lord Bingham says that good faith and significant imbalance seem to be cumulative requirements, but I wonder why he does that. It doesn't say that in the directive, the Court of Justice hasn't said it, and doesn't that ultimately make consumer claims harder? If the purpose of this directive is to protect consumers, then we want to give a construction to the statute which makes consumer claims as easy as possible. Okay, so those are that is the first leading case that I want to talk about. But what I'd like to do now is take a 5-minute break, and then we're going to go on to talk about some lower decisions, the big case of OFT and Abbey National, and then the rest of EU law. Now, there were a couple of other cases after the Director General of Fair Trading in lower courts, so it's worth mentioning those just very briefly. The Bankers Insurance Company Limited and South in 2004 saw Justice Buckley in the High Court hold an insurance policy exempting coverage for motorboat accidents was fair. So, somebody buys insurance and the contract term says, this doesn't cover motorboating accidents. Well, that's held to be fair, basically, I think, because motorboating is very dangerous and that's quite common in insurance contracts. And then there's this case called OFT and Ashbourne Management Services, one of the very few examples of a successful case brought by the regulator against a gin company. And so think about people who wake up on New Year's Day feeling a bit worse for wear, let's say, and after sort of all the holiday eating and stuff, and they say, okay, my New Year's resolution is I'm going to go to the gym every day. So Ashbourne Management Services had a term in its contract which had a minimum subscription period of 12 to 36 months. So you couldn't just have a 1-month subscription period to the gym. And if people terminated early, they would be classed as defaulters, and the gyms threatened to pass details to a credit reference agency. Justice Kitchen, I think, quite wisely said that this term was unfair. Think about all the poor old people with their New Year's resolutions that turn out to go badly. I think that must have been the right decision. Okay, so there's some other questions in the chat, but I'll come to those at the end if I can. Now, the big case that we've got to scrutinise next is called Office of Fair Trading and Abbey National PLC. And this was decided at the height of the global financial crisis in 2009 or shortly afterwards. And it was brought between, the regulator, who's arguing that terms used by banks are unfair, and then pretty much every big bank in the United Kingdom. Abbey National, Barclays, Clydesdale, HBOS, so that's Halifax Bank of Scotland, HSBC, Lloyds, NatWest, Royal Bank of Scotland, Nationwide, and also NatWest, which is part of the Royal Bank of Scotland group now. And if you ask, which banks do you have an account with, I bet that 95% of you, if not more, will have an account with one of those. Now, the term in question here, or the terms, were ones that related to customers' unplanned overdraft fees. So imagine that you go to the bank, or to the cash machine, and you put in your card and you get out 10 quid, but that takes you over your overdraft limit, maybe by £1, maybe by a few more pounds. if that happened, the bank said that there could be charges for going into an unplanned overdraft. So they give you the money out of the cash machine, but then they said that they would charge you anyway these unplanned overdraft fees. Now, these could mount to a very significant sum of money. One example was a young man called Ross Lewis, who was a student in Middlesex University, and in 2008 he was charged almost £300 for going £25 over his overdraft limit. So the question in this case is, were these unplanned overdraft charges fair? The Court of Appeal held two questions. First of all, that the term was not part of the price payable, so therefore it could be assessed for fairness under Section 64. But then, secondly, secondly, they would have to ask whether the term was fair. But the case ended there, and it got appealed to the Supreme Court on that alone. But from the statements that the Court of Appeal was making, it looked like that term was very unlikely to be classed as fair. And if it had been inquired into, I think they would have been right. But before there is any assessment of the fairness of the actual term, we've got litigation on whether you can assess it for fairness. And so that's what goes up to the Supreme Court. And the Supreme Court holds that what is now under Section 64, that the terms could not be assessed for fairness, and that all of this was part of the package of charges making up the bank's price or remuneration. So the consumers lose, the banks win. And on top of that, the Supreme Court says that this case shouldn't be referred to the Court of Justice of the European Union because the law was completely clear. It was acta claire. Despite the whole Court of Appeal, including the Master of the Rolls, deciding the case in exactly the opposite way. So how can it be that clear if the Court of Appeal has just held that the judgment that you're giving is the other way? But then there we were. So the UK Supreme Court never also asked whether the terms were fair. Under Section 62, it never gets to that point. And also it's precluding the possibility of the Court of Justice reaching another result because it's just not asking the Court of Justice what it thinks in a preliminary reference. So here's what Lord Walker said in his justifications for the decision. In paragraph 43, he points to First National Bank and he points out that Lord Steyne indicated that what's now Section 64 should be construed restrictively, and that Lord Bingham said that it should be limited to terms falling squarely within it. So we should construe this exception from the assessment for fairness in a narrow way. And Lord Walker says that he agrees with that, but he says the unplanned overdraft charges very squarely fall within the price payable in the contract, in Lord Walker's view. He quotes Hugh Collins in an article with approval, saying that the directive does not require consumer contracts to be substantively fair, but it does require them to be clear. But then he says, even if the Court of Appeal's interpretation had been correct, I don't see how it could have come to the conclusion that charges amounting to over 30% of the revenue stream were not a part of the core or essential bargain. So here he's alluding to the fact that the banks had argued that 30% of their revenue, incredibly on normal accounts, was coming from unplanned overdraft charges. 30%, that's a very big sum of money. And Lord Walker is saying that because the banks were taking so much revenue from these unplanned overdraft charges, they were more likely to be considered part of the core terms of the contract. And that's very problematic reasoning because it's almost like saying that if you use unfair terms a little bit, then it's more likely to be classified as not part of the core term, not part of the price payable. But if you use them like really loads and you've got 30% of your revenue coming from potentially unfair terms, then it becomes part of the price payable. In other words, it's almost an encouragement to use unfair terms on a much bigger basis, and that just can't be right. Lady Hale is a bit more circumspect, but ultimately agrees with the majority. And this is the quote that we started off with. She says, as a very general proposition, consumer law is about giving consumers the ability to make an informed choice, not stopping them from making unwise choices. And she says, as we mentioned before, that maybe the real solution relies or depends on more competition, not in cancelling unfair terms. But this is, I think, very surprising, or rather surprising, as Ewan McKendrick, again, the other Ewan in his contract law textbook, has put it. So, to sum up, the United Kingdom Supreme Court has said that, first of all, the main purpose of regulation is to ensure good information, but it completely ignores in its judgment the relevance of bargaining power. And that is a big problem because the directive directly talks about the importance of bargaining power. Secondly, the Supreme Court said that unplanned overdraft fees were part of the price payable for the bank account, but this ignores the fact that the main price payable in every bank account, as we all know, is that the bank takes your deposits and then it invests them in order to earn a return on those investments. And that surely, the right of the bank to take an interest rate that it makes on your money and give you a lower interest rate, and the difference between the two is the real price, the time value of money. That's the real price that banks get on bank accounts. And the third thing is that the Court of Justice, according to the Supreme Court, probably would have agreed with it, despite a unanimous Court of Appeal, and despite the UK Supreme Court actually declining to make reference to the Court of Justice and therefore never finding out. So, as I say, Ewan McKendrick says that this result, in his contract law book on page 455, this result came rather surprisingly to the conclusion that it did. And so, when you've got an English contract law professor like Ewan McKendrick saying that something is rather surprising, then that is tantamount to saying it's probably wrong. In a sort of very, very reserved, understated way. I think that there was a lot of criticism for the UK Supreme Court on the OFT and Abbey case because it meant that in the middle of the financial crisis, consumers could be ripped off. Now, that wasn't the end of the story, however, because Lord Walker did stress that bank terms had to be transparent and they had to be prominent in order to meet the legislation's requirements. And so with some regulatory pressure, even though they didn't win, banks were forced to shift their practices surrounding unplanned overdraft fees because the regulator said, well, these fees are not transparent. But that didn't do anything for Ross Lewis and the 300 quid that he had to pay, or all the other hundreds of thousands of people who were charged unfair fees. And that by itself is not an ideal result. So now let's talk a little bit more about the ideas of information and bargaining power and take a closer look at the European Union's case law before coming back to the case law of the UK Supreme Court, where we see a very, very different picture in the inspirations for the judgment and the principles behind the reasoning of the Court of Justice judgments. So we see that particularly in cases like Aziz or Kusinova, and then we'll come back to Parkingai and Beavis in the UK Supreme Court. So I think the first leading case is a big one from the Court of Justice, and I think this one is even from the Grand Chamber, called Aziz. So in this case, Aziz claimed that Clause 15 of his mortgage contract was unfair because what it did is it substituted an interest rate of 18.75% interest per annum if he defaulted. So you're paying a certain amount of interest in your mortgage contract, but then if you miss a payment or you default, then a higher interest rate is going to kick in. And presumably the bank's argument for this is that, well, people who default have higher risk, so we need to charge higher interest. On the other hand, that makes it inherently less likely that somebody is going to be able to afford the interest rate repayments and therefore pay off the loan. It puts people who are in debt into an even worse position. So the question was whether this was fair. The normal rate of interest was 4.87%, and Spanish law limited the default rates in other consumer contracts to 2.5 times the norm. So the Court of Justice held that the Spanish court should have to assess whether the term is actually fair, and it has to do this of its own motion, even if the parties haven't brought up the issue within a court case. There's an obligation on courts to look at whether contract terms are fair on their own motion. And also, the Court of Justice notes that the Spanish court should have to provide an effective remedy, asking whether or not a consumer contracting in good faith would agree to this term. So it's saying that the test for fairness, or one helpful way to determine whether a contract term is fair, is that you ask hypothetically, would a consumer contracting in good faith have agreed to this term? Under paragraph 44, the court says the following: the system of protection introduced by the directive is based on the idea that the consumer is in a weak position vis-à-vis the seller or supplier as regards both his bargaining power and his level of knowledge, and that the goal of consumer rights is to re-establish equality among the parties. So contrast paragraph 44 here to the Office of Fair Trading and Abbey National case in the Supreme Court, where Lady Hale is talking about information. No, says the Court of Justice a few years later, this is about bargaining power and information and your level of knowledge. It's not just about information. At paragraph 68, the court says it should consider the national rule that would apply by default to decide whether there's a significant imbalance. So what it's saying there is we imagine what the interest rate would have been without the unfair contract or potentially unfair contract term. And in asking whether there's a significant imbalance, we say, well, how far away from that term is the term in the business contract? So 18.75% is a lot more than 4.87%. Therefore, it's very likely that this is going to be considered to be significantly imbalanced. And also ask whether the consumer could have agreed in good faith to such a term. So that's Aziz, and the same basic principles have been repeated again and again in many, many cases in the Court of Justice. One of them is called Bruza and Jahani BV in 2013. Here you see the Court of Justice essentially repeating what we said before. The directive is based namely on the idea that the consumer is in a weak position vis-à-vis the seller as regards both his bargaining power and level of knowledge. So it's not just about information, it's also about power and about rights. Now, you see the UK Supreme Court in a very different place to the European Court of Justice, but it's also worth going over the Atlantic briefly to look at what's happening in the US Supreme Court at around the same time. And things are far, far worse. So one of the leading cases, and again there are many, is called AT&T Mobility and Conception. So AT&T is the big telecommunications company. And in this decision, the US Supreme Court goes so far in the opposite direction from consumer rights that it's almost off the chart. It held in this case that if a big corporation like AT&T has a term in its contract that binds a consumer to arbitration, where even if the arbitrator is selected by the corporation and therefore deprives the consumer of any remedy of going to court, then this has to be enforced according to its terms. So effectively, in this case, the US Supreme Court, a 5-4 Republican to Democrat appointee majority, abolishes all consumer rights in their effectiveness. It essentially has done the same thing for employment rights in a case called 14 Penn Plaza, binding people to arbitration. And that's precisely the thing that is on at least the grey list of unfair terms in Schedule 2, paragraph 20 of the Consumer Rights Act, and also in the directive. Remember, Uber and Heller was, of course, about an arbitration clause as well. So that is the extreme opposite of consumer rights, effectively saying that big businesses can dictate whatever terms they want. And I think that's important to keep in mind, when we're thinking about financial crises and the role of courts and the role of law and the consequences that it has. Um, This also goes to, I think, something even more than just consumer rights, because it begins to connect, especially when we're talking about somebody's home, or to people's homes and mortgages, like in Aziz, to people's fundamental human rights. So in the European Union, there is the Charter of Fundamental Rights of the EU in 2000. And this is very similar to the European Convention on Human Rights, but we're just going to focus on this because it's EU law, and this informs the Court of Justice decisions. Article 7 says everyone has the right to respect for his or her private and family life, home, and communications. And we'll talk a bit about this a little bit more next week. Article 8 also says this right, or rights like this, extend to the protection of your personal data. Okay, so there's human rights involved also in many contracts, and this, I think, is relevant for the interpretation of consumer protection. It goes on in the Charter of Fundamental Rights to Article 38. Union policy should ensure a high level of consumer protection. And by the way, there's nothing in the Charter of Fundamental Rights that says that businesses and big corporations are entitled to a high level of protection. So, the basic norm is that consumers, not big businesses, are entitled to a high level of protection. And Article 47 says that there is a right to an effective remedy. Now, we saw that coming in, the idea of human rights being relevant for consumer law, coming in to the case law for the first time in a decision called Kushyanova and Smart Capital in 2014. So here, Kushyanova had borrowed 10,000 euros from Smart Capital, secured on a home. And the contract said that security could be enforced without any court review. So that's restricting your right to a remedy in a public court. It's saying that the contractual security can be enforced by the moneylender or the bank without any review by the court. So Kushyanova claimed that this term was unfair, and for us, it's the Consumer Rights Act, Section 64 and Section 62. The Court of Justice held that the directive had to be construed in the light of the rights under the Charter of Fundamental Rights of the European Union, and that there is a right to go to court. And here's the important bits, starting with paragraph 48. Again, it repeats this idea that we saw in Aziz and Bruza. The court has already held that the system in the directive is based on the idea that the consumer is in a weak position, both as regards bargaining power and level of knowledge. But then it says even more. The European Court of Human Rights has held that the loss of a home is one of the most serious breaches of the right to respect for a home. And secondly, that the person who risks being victim of such a breach should be able to have the proportionality of the measure reviewed, and then see cases like McCann in the United Kingdom. And it goes on even further to say that under EU law, the right to accommodation or housing is a fundamental right guaranteed by Article 7 of the Charter that the referring court must take into consideration when it's interpreting or implementing the directive. So when we're looking at the meaning of the meaning of consumer rights, the Court of Justice is indicating that we should be interpreting them according to what fundamental human rights norms mean. So that could be true in the EU for the Charter of Fundamental Rights, in the UK for the European Convention on Human Rights, or it could be true for international treaties that we've signed, like the International Covenant on Economic, Social and Cultural Rights, which reflects ultimately the Universal Declaration. And that, I think, is a big topic that we're going to come back to next week. It's not the case, however, that the Court of Justice of the European Union has always done pro-consumer decisions. And that's particularly true in this case called Barclays Bank SA and Garcia and Barrero. This was about a Spanish statute that enabled a bank to buy the property of its owner at half the contractual reference value. So the contractual reference value, the price of the home, was 149,000 euros. And it could do that if the homeowner had defaulted on mortgage repayments. There had to be an auction to sell off the house to get back the debt. But then if nobody turned up to the auction, the bank could take the house at half the contractual reference value. And so that meant that Barclays got a house for £74,000, about half of what it was worth. And then on top of that, it pursued Garcia and Barrera for the outstanding 95,900 euros. And so the question was whether this was unfair. Unfortunately for Garcia and Barrera, the Court of Justice held that because this term came from a Spanish statute, so it's a contract term, but it reflected what the Spanish statute said could happen. The source of the unfairness was not contract terms, and therefore it's outside of the scope of the directive. It's only from a statute, and therefore you can't assess it for fairness. So that, as I say, is an example of a case in the Court of Justice which doesn't go the way that consumers want. But otherwise, there are very, very significant differences between the Court of Justice of the EU and the UK Supreme Court in recognising bargaining power, in upholding rights, and also squarely bringing in human rights into the interpretation of the law. Okay, so now let's come back to the most recent leading case in the UK Supreme Court, where, spoiler alert, the consumer loses again, called Parking Eye Limited and Bevis. Really, really simple case, really, really simple facts, but ones that seemed a bit too difficult for the majority of the Supreme Court to award a win to the consumer here. This is also joined to another case called Cavendish Square and Makdessi on penalty clauses, which I think that you will have talked about with, or will talk about with, in Professor Macmillan's lectures a bit later. So here, you had a sign outside a parking lot, and it said Parking Eye, car park management, 2-hour maximum stay, customer car park only, 4 hours maximum if you're going to the gym. Of course, people often don't go to the gym because they don't last that long after New Year's, but 4-hour maximum stay for them. Failure to comply with the following, here's the point, will result in a parking charge of £85. Da, da, da. So the question is whether it's unfair. And I've highlighted those in red, but you didn't have a big red hand pointing to it, and it wasn't written in red ink so far as I know. So is this an unfair term? The majority of the UK Supreme Court hold no. Lord Neuberger and Lord Sumption give the first judgment, and they hold the term is not unfair, although it could be assessed for fairness because people accepted it. At paragraph 108, there's the core of the judgment. They reason in the following way. Could Parking Eye, dealing fairly and equitably with the consumer, reasonably assume that the consumer would have agreed to such a term in individual contract negotiations? So what it's doing here is applying the hypothetical contracting test from Aziz to ask, would somebody have affected this term if they were dealing openly and in good faith? The question is not whether Mr. Bevis himself would in fact have agreed to the term imposing the £85 charge in a negotiation, but whether a reasonable motorist in his position would have done so. Okay, so Mr. Bevis drives his car in and then he drives away, but he does it a bit too late. He gets the £85 term, the £85 fine. The Supreme Court is saying it doesn't matter whether Mr. Bevis himself would have agreed, but whether a reasonable motorist would have. And then they say, magically, in our view, a reasonable motorist, and I think the emphasis on our view is important, a reasonable motorist would have agreed. In the first place, motorists generally, and Mr. Bevis in particular, did accept it. Now, that's a bit of a stretch because most people probably didn't even notice it. In the case of a non-negotiated standard term, that would not ordinarily be entitled to much weight. But although the terms, like all standard contracts, were presented to motorists on a take-it-or-leave-it basis, they could not have been briefer, simpler, or more prominently proclaimed. If you park here and stay more than 2 hours, you will get £85 in fines. Motorists could hardly avoid reading the notice, and they were under no pressure to accept the terms. So, there's nothing particularly wrong in this reasoning, except for the fact that it just depends on their view. and what they have as preferences might be different to what other people think, and this is not the same as objective reasoning. However, they managed to get the majority of the Supreme Court to follow them. Lord Mant says a consumer would have asked for a graded charge, but he wasn't sure that just an £85 charge was unfair. Lord Hodge said he has some doubt, but he was persuaded. Lord Clark, who was the judge in Office of Fair Trading in Abbey National that originally said the bank charges could be assessed for fairness, doesn't say much at all. But I think the most important judgment here is really Lord Toulson, who dissents. He says a reasonable consumer would not have agreed, and he lights one very important reason, which the majority failed to talk about. He notes that an £85 charge can often be most of people's weekly income. So imagine that you've got somebody who is on a state pension and they're getting, I think it's now £135, but back then it would have been much less, maybe just over £100. This would be 3/4 of your weekly income. And maybe this very unsurprising unfair charge is going to mean real financial consequences. And so that is important in taking into account whether or not this charge creates a significant imbalance. So, the one good thing that the Supreme Court majority did do is it did say, okay, this is not a core term. It is part of the price payable, but it's not a core term. It's an ancillary term, right? The main term of the contract is you get a free parking space for 2 hours, and then you go and get to use the shopping facilities. So, one good thing is, unlike OFT and Abbey National, they say it's not a core term or not part of the price, but then they just say it's fair anyway. Lord Toulson is very critical. He says Lord Neuberger and Lord Sumption in paragraph 107 has substituted their judgment of the reasonableness of the clause for the question whether a supplier could reasonably have assumed that the customer would have agreed to the term. And at the very least, the point is not acte clair. So again, like in Office of Fair Trading in Abbey National, the Supreme Court refuses to refer the case to the Court of Justice, even though one of the judges in the Supreme Court itself says that the case is not clear, and he dissents, and he says it's not acte clair. And that, I think, gives you an indication of how reluctant the UK Supreme Court was to refer cases to the Court of Justice, perhaps because it just didn't like the result that it knew that it would get from the Court of Justice of the EU. Now, that's really the end of the the statutory provisions for the Consumer Rights Act 2015. But it's important to see that there's a big ecosystem surrounding these terms and the requirement, or these rights, and the requirement that terms have to be in good faith and not create a significant imbalance. There are many specific rights that we see all over the place, depending on a specific kind of transaction. So one example is the Train Passenger Rights Regulation. That says, for example, in Article 17, that if you buy a train ticket that's over a price of €4, then you should be refunded 25% of the ticket price if there's a 1 to 2 hour delay, 50% if the delay is more than 2 hours, and at all times you should be kept informed of what's happening, and refreshments should be made available. So this counteracts, train companies potentially saying, well, if we delay you by an infinite amount of time, then we exclude all liability. But a balance is being reached about, what is reasonable between the consumer and the train company in the case of delays, which is sometimes unavoidable. So that's the Train Passenger Rights Regulation. You've got something similar for flight delay, the Flight Delay Compensation Regulation. But all of this at the moment seems like a distant memory, since with COVID, you can't go anywhere anymore. But maybe one day in the delightful future that lies ahead of us, we might actually see we might actually see that, trains again and planes again, where we can go on holiday. And remember that all EU regulations stay in force under the Withdrawal Act, Section 3, but unfortunately UK citizens lost the right to request preliminary references to the Court of Justice of the EU. Okay, now we get to the fun part, which was, how does all this stuff that we've said apply to the homework that you've been set on making contracts or making agreements great again? A lot of you have done very, very interesting, very colourful answers, very varied as well. So I thought it might be useful to go back over the sort of main points and what you've seen in the lecture terms that have been set. And by now, if you haven't guessed it already, all of this is entirely a joke, and I was never intending to be serious. But I think, in the real world, these things really do matter because unfair contract terms are everywhere and used in exactly the same ways as I have done in my appalling contract lecture terms. So what you agreed to at the start by clicking I accept is blah, 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 blah. But then the important bit is in red that you accept the further terms and conditions as may be revised from time to time by the lecturer. And that gives me unlimited, arbitrary, discretionary power. And surely that is the starting point of the problem. Then what happened is I varied the terms to require, some very light homework, which I think is totally reasonable at the beginning, with a screenshot of an unfair term. And then I said, well, if you didn't do that, you had to provide 150 words on why the lecture terms are fair. And then if you didn't do that, I raised the requirement to 250 words, and then also explaining the Carlyle and Carbolic Smoke Ball Company, or the Carbolic Smoke Ball Company advertisements. And I also threw in some extra fun stuff like, failure to comply with the homework assignment, howsoever caused, so that's like a Hollier and Rambler clause, may lead to be not getting the lecture, the future lectures and the links at my absolute discretion. So again, I'm reserving unlimited power for myself. And then I added some other things about taking intellectual property over your homework. That's definitely problems under the Copyright Act. Arbitration, so that's what we've seen in Conception and Uber and Heller, and all liability for death and personal injury being excluded. And then I also said I might impose some other terms and conditions about musical performances and experimental art and interpretive dance. So I hope none of you took it too seriously, but that should have been the giveaway if you did. So how would you actually approach all of these radically unfair terms if we applied the law, as we've learned in lectures? How would you get through all the law, and can we make agreements great again? The first thing is that you did click that you signed, that you clicked that you accepted the lecture terms. So, Lestrange and Graucob, is the authority on signatures, and the Law Commission says clicking is like a signature. And I think that most people accept that. But the real problem is whether the terms are fair or not. Surely it shouldn't matter what the form of somebody's acceptance is. That's a pretty archaic rule. So if we go over that, we get to the second point, which is that even if you didn't click that you accept, and some clever people thought, well, haha, I'm not bound, right? Even if you did click that you accept, you still had reasonable notice of the terms, and it was necessary for continuation of the lecture. So even if they were onerous, they were brought directly to your attention. So this fulfills all the criteria in Ollie and Marlborough Court, or Thornton and Shoe Lane Parking, and even Interphoto. The more onerous the term, the more notice needs to be given. You got notice right up front at the beginning of the lecture. So even if you didn't click that you accepted, you probably would still be bound if we apply the reductive rules at common law. Now, then there's not really any problems with interpretation. So a reasonable person, given knowledge of the context, would think that the terms mean what they say. That I've got discretion to change the lecture terms as I want. So that's ICS and West Bromwich. However, the discretion in the term does meet problems under the common law tests on implied terms. So we have the rule that discretion should not be used in a way that would defeat the reasonable expectations of the parties. And so we see that coming through, particularly in the House of Lords in Equitable Life and Hyman, and then also in Johnson and Bloomsbury Helpful Authority. But then the question goes, well, does me requiring you to do homework when you're at university doing a degree violate your reasonable expectations? And I'm not sure that it does. I think that there's other things, but, just asking you to do homework, if we wanted to see this as a contractual relationship, which personally I don't, If we wanted to see this as a contractual relationship, I'm not sure that it would be unfair purely on that basis, even though I've reserved discretionary power for myself. So it's how you use the discretionary power that really matters, right? Not just the fact that there's a discretion, but that is one of the most powerful rules of common law to regulate contracts like this. Now, then we get to the stuff that we've done today, like the Consumer Rights Act, Section 65. Um, One person asked in the chat, don't you already have sufficient homework? The answer is you can never do enough work. You're lawyers. It's just unending, believe me. But nice try. So the Consumer Rights Act, Section 65, makes a term excluding liability for injury or death completely invalid. So that's obvious. So the one back up here where I said all liability for death and personal injury is excluded. Well, that one definitely wouldn't work. And the one about arbitration here is contrary to paragraph 20, as you know, the case of Uber and Heller, or AT&T and Conception. But what about excluding? You know, if I threatened to exclude you from the lectures, you know, if I had ever been so horrible that I would have actually done that. And by the way, don't tell the first years next year. But if I'd actually done that, what would be the effect? Well, Section 2 of the Consumer Rights Act probably does make you a consumer. And I will talk about that a little bit more next year. But unfortunately, you know, because of tuition fees and the commodification of universities, it's probably the case that you also count as consumers. But the good thing is that that gives you more protection. So then the question under Section 64, you know, this isn't about price, in Section 62, I should say, is you know, whether this creates a significant imbalance contrary to good faith. And again, I'm not sure that getting you to do homework does do that. However, paragraph 11 of Schedule 2 does require a valid reason for me altering terms and conditions of contracts. It all depends on whether or not you think what I'm doing is fair. Now, I'm going to leave it open. I think, no, maybe probably my contract terms are fair. But what I want you to think about is, why do we have to go through all of these 7 steps? Why not just say that contracts of unequal power must be fair? And a number of people in your answers did actually bring this up regarding AutoCleanse and Heller. Okay, so that is the contract lecture terms. And I also just want to say, well, you know, whatever the fairness of the lecture terms, this one definitely is unfair, as many of you pointed out. So the Carbolic Smoke Ball Company said that a £200 reward would be payable, you know, after they got taken to court for anyone who used the smoke ball and still got a disease. The carbolic smoke ball would never be sold today because it would be subject to regulation under health and safety legislation. The National Institute for Clinical Excellence would never let the carbolic smoke ball come to a market. But even if it did, I think that the Carbolic Smoke Ball Company saying that you get £200 if you use the smoke ball would inevitably involve an unfair term, because carbolic acid is dangerous. It makes you cough. You shouldn't be breathing it in. It makes you sick. It's highly likely to cause personal injury, if not death. And so it would a term of a contract requiring you to use it would definitely be unfair. Perhaps you could even argue that you should get the reward without using it at all. Now, the reason why I go through all of this is because we remember things more if I get you to do homework, if you start thinking about things, if you even discuss these things, and hopefully if it's a bit funny, if it's a bit interesting, you're likely to do that more. William Glaser, quoted here in an education textbook, gives a rough guide to how much the average person retains, or how much we remember. So we're likely to remember about 10% of what we read, 20% of what we hear, 30% of what we see, 50% of what we see and hear. So, you know, on YouTube and stuff, that's probably about 50% is going to go in and stay. But you remember 70% of what you discuss. You remember 80% of what you use in real life. And you remember 95% of what you teach to other people. So my advice to all of you is, as much as you can, teach other people about unfair contract terms, and that's the best way to teach yourself. Okay, last part of the lecture, and in the last just few minutes, I think I'm going to skip over this quite quickly. I'm going to go through some different consumer regulation strategies. We'll go a tiny bit over the hour, but this stuff you can read about as well more in the textbooks. There are different kinds of consumer regulation strategies, and the key issue is which ones work best in order to uphold consumer rights. Three broad alternatives are the following. We could allow the markets to regulate themselves, and we could say that market competition is most likely to give consumers the best quality products at the best prices. The problem is that this strategy is important in the private sector of our economy, but it's highly ineffective when there's very unequal bargaining power and very unequal information. So Friedrich Kessler's famous article on contracts of adhesion is all about that. A second regulatory strategy against unfair terms is we can have the right to go to court and regulators administering legal rights and duties to cancel unfair terms. That's basically been the whole lecture today. The limit of this, however, is that it only ever creates minimum standards, and for its effectiveness, it requires active courts, active regulators, and we have seen that there are very big problems with both of those things in UK consumer law. A third alternative is that people who are otherwise consumers have voting rights in the organisations where they rely on services or goods. So if they've got a long-term relationship, like with a bank, like with a telephone company, like with a water regulator, then we can have additional governance structures, including voting rights, either through democratically determined decisions from Parliament over a public body, or directly for consumers. And that goes beyond contract law into enterprise law, which we could do in future years if you come and join the enterprise course with me later on. But these are not alternatives, they are complements. So there's not sort of one way in which you can realize consumer rights, just through markets or just through courts or just through public ownership and governance solutions. They are not alternatives, but they are complements that build on and reinforce one another. There are, I think, important limitations to all of them. So competition can only work, and we're just looking down at the bottom of this slide, competition can only work in limited ways. If you've got all businesses using the same terms, then competition is not going to exclude unfair terms from the market. So Jensen Meckling put that point across in the 1976 article. It is true that consumers can vote with their feet, so you have effective competition. That's a very strong sanction. But businesses losing business so much that they go insolvent is often a very bad way to regulate markets, because insolvency can be so detrimental. But then we've got courts. So courts can be good because it doesn't cost very much to file a claim at a county court. Consumers can do it. They can bring individual claims. The difficulty is that it's just very unlikely. Often people don't know what their rights are, right? You have to do a contract law course often before you know all about your consumer rights. I mean, it is getting easier and easier. So if you go to moneyclaim.gov.uk, you'll see that there are pretty easy ways that you can bring a small claim. Then we really need courts to be active, and we've got to ask, what incentives are there for courts to fully uphold consumer rights? One of the big problems is that you have people getting onto the Court of Appeal, onto the Supreme Court, who have spent a very long time as commercial barristers, perhaps defending big corporations. And so we might ask, well, given the background of judges, do they always have the best incentive to uphold consumer rights to the fullest? They might, given their background, be extremely skeptical. So then we've got regulators, but the difficulty is, although regulators are meant to, and excuse me, skipping around a bit, but although regulators are meant to be active in prosecuting unfair contract terms, We don't always see that happen in practice. So today, the regulator in the UK is the Competition and Markets Authority, and it's got a set of duties under Schedule 3. So it's the successor to the Office of Fair Trading or the Director General, and it can apply for injunctions, it can accept undertakings, it can require information. It's got lots of powers, but it hasn't always used them very actively. The OFT before only brought 2 successful cases in 10 years and brought nothing or had no success from 2003 to 2009. The Competition and Markets Authority has not been massively active in exactly the same way, and so this is highly problematic. Okay, so the conclusions for this lecture are as follows. The first thing that I tried to persuade you of is that consumer law is about redressing unequal power, not just giving people good information. And I think that's very clear when we look at the European Court of Justice's case law. Second of all, the central weakness in consumer rights at the moment is that the standards are very minimal and they depend on courts which are often reluctant to interfere in big businesses' freedom. So, and the third point is that while the law's existence may deter some unfair terms being used, the absence of real victories in the UK courts for consumers, losing Director General of Fair Trading, losing Abbey, losing Parking Iron Beavis, and the absence of significant enforcement action shows that consumer rights as they stand are really not enough. So arguably we need to put all of this into a broader and more robust human rights framework, and that's what we'll be talking about next week.